There's a famous saying in the blogosphere, TLDR.
So what does TLDR mean?
Too long, didn't read.
I'm sure that is a problem that goes beyond the internet.
Yes, you're right. And today we're going to talk about an application in the field of patent law. And I'm joined by my colleague, Daniela Seele.
Very happy to be here.
Happy to have you.
And today we're going to be welcoming Professor Michael Frakes from Northwestern University to talk about a potential problem with patent examinations.
Okay, perfect. So let's jump right in.
Okay, so first remember how a patent comes to be. An inventor has an idea that he thinks should get a patent, writes it down into an application and hands this over to the patent office.
The patent office examiner takes this application, he looks through it, he tries to assess whether all the legal requirements such as novelty, obviousness are fulfilled, and if he's satisfied, he pursues to grant the patent.
Wait a second though, I've got a few more ideas that I would like you to look at. That brings us to a policy question. The time and money that the patent office has to go through the patent applications and examine them is limited. Thus, they have two options. Either they do substantive examinations of every application at the office and only let good patents through, or they do less substantive examinations and have the courts take care of the rest. So kind of push it back to the courts.
And this is exactly what our guest Michael Frakes and his co-author Melissa Wasserman look at in their paper Irrational Ignorance at the Patent Office.
They draw on a wealth of data and empirical studies to compare the costs and benefits of these two options. They, as we will see, reached the conclusion that it would make more sense and be less costly to society to have more substantive examinations at the Patent Office. So to solve the problem ex ante.
But first, let us find out a little bit more about our guest, who's joining us from Duke University, Professor Michael Frakes. We asked him a little bit about his background and what led him to write this paper in the first place.
I have a background in study both economics and law. I studied law at Harvard. I did a bachelor's and a PhD in economics at MIT. And some of my work in healthcare brought me to a fellowship after my doctorate at the Petrie-Flom Center at Harvard Law School. And one of the great things going on at the Petrie-Flom Center was this academic fellowship program where fellows would spend a couple of years there in residence and develop our scholarship. And there were scholars like me in health policy, scholars in bioethics, and as it turned out, scholars in patent law. And this is where I started at the very end of the fellowship. I started working on some projects with Melissa Wasserman, who's the co-author on the paper that we're talking about today.
So the paper points to a fundamental question in patent regulation, which is either the patent officer is doing a really substantial and detailed analysis of each patent before he actually approves the patent, or there's a simpler option, which is basically he can take all the patents and just push the entire decision to the court system.
So this actually points to a larger policy question, which is, should we regulate ex ante at a large number of activity but low cost per activity? Or should regulation focus ex post with the courts with a low number of activity but high cost?
And this is exactly what we asked Michael Frakes.
Mm-hmm. So we asked Michael to explain us why this dilemma is important to think about and why the Patent Office is a good place to examine it in more detail.
There's been much discussion about the U.S. Patent Office issuing too many patents, particularly too many invalid patents that can drain consumer welfare and can be very harming. We have another institution in the U.S. that could also deal with this problem of invalid patents, and that's the courts. And so, yes, we could, if we sort of have the Patent Office that might be allowing too many invalid patents to go through, it can be corrected at the courts later on. And Professor Lemley suggested that maybe that's more cost-effective to the extent that those patents will be rarely litigated. Yes, they'll be very expensive when they are litigated, but it's rarely litigated enough such that maybe our resources are better spent doing regulating in the sense of invalidating these bad patents ex post via the courts. Ultimately, though, this turns out to be a simple sort of cost-benefit exercise. Really, what is the most cost-effective way to dealing with the issues of bad patents? Addressing them up front with a more rigorous examination review, or sort of leaving and reserving the problem for the courts. And this is ultimately what led us to the particular project.
So the question of whether or not the Patent Office should be given more time to look at each and every patent application in detail has been discussed a few times in the IP literature. In perhaps the most famous article in this literature, Professor Mark Lemley has argued that because only very few patents actually make it to the courts, we should limit thorough investigations to those few economically relevant cases and thus limit the costs to society only to these few cases. He argues that giving examiners only a limited amount of time thus amounts to the Patent Office behaving rationally ignorant.
Exactly. And our guests, Michael Frakes and his co-author, Melissa Wasserman, they come to the exactly opposite conclusion, saying that the Patent Office is acting irrationally ignorant by limiting the amount spent on each and every patent, and that society would actually be much better off if we gave them more time to do a thorough investigation.
Yeah. So we asked Michael to explain us why they come to the opposite conclusion from Professor Lemley, and why it is that their cost-benefit analysis has reached a different result.
Right. So this question it pops up all the time when we think about how to regulate in many areas. So should we regulate upfront, sort of a more ex-ante approach, often in the form of some sort of administrative agency, taking some arguably command and control type approach to the problem? Should we reserve the regulation for ex post via legal rules and via sort of the litigation process? It's definitely absolutely not unique to the patent context. I have this discussion with my students there as well. Should we take a more ex-ante approach via various tools that we could sort of try to sort of shape physician behavior up front, or are we happy to sort of take the approach that we actually sort of rely more upon in the medical context is the ex-post litigation approach, often in the form of a medical liability regime. And we've opted more for the ex-post approach there, but not without much discussion. What can we learn from the patent context? I mean, just as always in situations like this, I would imagine that the answer is going to be ultimately context dependent. So our specific results with the rigor that we applied to it suggest that we do think that probably it would be wise to sort of invest more on the margin relative to our status quo in ex-ante review of patents. Now in our analysis, we focus on the simple question of giving examiners more time as one form of investment. And we have a number of reasons why we were focusing on that. One is a methodological. We had the ability to actually sort of implement that particular design because we had the ability to sort of explore what is the relationship between the amount of time the examiners are given and these various outcomes. Two, because this is something that the Patent Office is at this moment considering. They are reconsidering their examination time allocations. We hope that our analysis will be helpful for them. And then three, as I mentioned before, that Professor Lemley had really sort of kind of started this conversation around 17 years ago, and in particular in the patent context. And he was really focused on examination time as his sort of driving question about the types of investment we can do up front. And so we're trying to work within the framework that he started as well. And so bottom line is there's many different ways that one can take this ex-ante versus ex-post discussion. It's no matter what context we explore it in, physician context, if we do it in the securities context, if we sort of do it in the patent context here, there's going to be a lot of different sort of design choices about how to construct various inquiries.
So Melissa and Michael in their paper compare the costs and benefits of two different options. First, having a thorough, long, substantive examination at the Patent Office, or second, only having a limited, shorter, but still substantive examination at the Patent Office.
That's exactly right. And Switzerland has chosen a third option, which is to forego all substantive review at the examination level and to focus only on the formal requirements, which has, of course, given the patent examiners in Switzerland a lot of time to come up with their own ideas.
Exactly. So we asked Michael because we were wondering, given the wealth of data he's collected and the extensive cost-benefit analysis that he has done, what he would think this third option would look like in the US. So what would be the advantages and disadvantages of the USPTO only looking at formal requirements of patents and giving the entirety of substantive examinations to the courts?
Right. And first, I'll start with, Professor Lindley sort of had a powerful insight there, which was, yes, even though sort of litigation is more expensive, it's so rare that ultimately in the aggregate, those expenses could be less than ultimately spending more upfront on absolutely all applications, which is what you would do if you invested more in the time per application. It's a powerful insight. I think it's powerful in the sense of raising what is at the end of the day an empirical question, which actually sort of turns out to be more expensive, investing more in the agency, or and if you do so, that could ultimately save litigation expenses down the road. And so ultimately it's sort of a question of the litigation expenses that you can save to the extent the litigation expenses would be spent on trying to invalidate bad patents, how much of that can be saved by eliminating those bad patents up front. It's just simply an empirical question whether those savings could be will outweigh the cost of examination review. And then ultimately there's also questions of what other types of savings or what other types of costs really should go into this full cost-benefit analysis. Is it worth it to invest more at the agency level? And so we actually find at the end of the day, if anything, we don't see that examination fees per round of review go up. And also, if anything, interestingly, we actually find evidence suggesting that the number of rounds of review during this patent examination process may go down as examiners are given more time. The net result of all of this is we think, if anything, there might be savings to prosecution expenses that could come from giving examiners more time. So we would probably approach this thinking this might be a potential cost, but if anything, our analysis suggested that might actually contribute to savings on the other side. Now, the big saving on the other side that we envisioned from the get-go is what I had already sort of mentioned. You invest more in the patent office, you can sort of knock out a lot of bad patents there. And if much of our litigation expenses are sort of focused on trying to invalidate bad patents, we might see potential litigation savings. And bottom line, through our estimation strategy, this is in data that we could sort of link our information on the patent application side with information on ultimate litigation outcomes. And using our strategy to sort of explore what's the effect of time allocations on various outcomes, we can just simply directly estimate the amount of litigation savings that could come from this sort of hypothesized doubling of examination time. And what we find there is also considerable savings when we sort of use appropriate discount rates for considering that the litigation savings are going to come a little bit down the road. That turns out to be about $490 million in savings for federal litigation expenses, and then we have also about $112 million in savings for PTAB, the Patent Trial and Appeals Board, related legal expenses under sort of similar mechanisms to the federal litigation expenses. When you add up those savings, and then you also add on the savings and prosecution expenses that I mentioned previously, that considerably outweighs the additional cost. And so that alone it suggests that the savings are going to outweigh the cost from doubling examination time. And then, as it turns out, there's a bunch of things that we sort of think go into this calculus, but we can't actually put numbers on. But everything else that we sort of have in the discussion is really on that savings side as well.
So, as we've seen, the paper presents some really convincing evidence that if you conduct a thorough cost-benefit analysis, the USPTO should be given more time to examine each and every patent.
So what we were wondering was, what are the concrete policy implications of this paper? Is it simply a case of giving every examiner more time? Or do Michael and Melissa argue for something more precise?
Do our results that say on the margin that it's actually more cost effective to invest more relative to the status quo, does that also imply that it's definitely the case that it's also would be cost ineffective to sort of move back in the other direction? But I do think it's one of the implications of our analysis is not just simply it's more cost effective to go from where we are and to sort of move forward and to do more, but it also would be ineffective from a cost perspective to move backwards and to sort of review less. Another interesting thing that I heard about the Swiss system is about the ability for those who've heard one of the patents have been issued, without a substantive review, and they have the ability to sort of bring forth basically sort of a request to sort of have a review done. And ought we think about something similar in the US? I mean, the reality is we actually sort of have, and I haven't really discussed this yet. In the US, we have sort of developed sort of a middle ground option of that particular sort as well. So to keep the analysis clean so far, I've talked about, ex ante examination by the examiners or sort of reserving it ex post for sort of, the courts to review the validity of issued patents. Ultimately, we could think about this as being akin to and similar to what it sounds like the Swiss process is. Certainly some differences. Now, the PTAB proceedings are actually sort of really quite formal-like, and sort of, they're not sort of full-blown litigation proceedings, but they have sort of many of the characteristics of those proceedings. So it sounds a lot more involved than just sort of a third-party challenger, so to speak, sending in a request for some sort of scrutiny to be done. And so ultimately, bottom line is, I think that the U.S. has considered something similar to what Switzerland is doing there, but ultimately probably in a slightly more rigorous way. Whether or not that's prudent, and whether we design this alternative, this PTAB system, in the best possible way is, I think, still an ongoing question. I tend to probably be more risk averse in this front, and so ultimately what I'm trying to do is, and kind of speaking for myself, and and not necessarily speaking for Melissa, though I think we're relatively on the same page, trying to sort of ultimately encourage the Patent Office, at least as a starting point, to reconsider its time allocations. And ultimately, we do think that they are reconsidering them now, which is a big deal, because ultimately over the last 4 decades, they've only ever done sort of one shift in their time allocations at all. And so and that was a relatively minor one, so the fact that they're actually sort of putting a lot of thought into this right now is a big deal. And we were told that it was partly, among other things, our analysis that might have sort of helped contribute to to this particular movement. And so I think we're encouraged as a start at that point. But then ultimately, what should we tell them to do? Like, for instance, should we tell them to sort of double the amount of time given to all examiners? And I definitely hesitate to say definitely do that. I mean, that's how we frame the cost-benefit analysis. And as we talk about in our paper, we think our results generalize to a much more modest expansion in the amount of time. Ultimately, I might sort of err on the side of starting cautiously and not do something sort of too aggressive, especially given the financial implications. But we do think the case is there to do something. And so there might be, as always, I might like to, one thing that could come out of this would be great if we could sort of, with our research, have it sort of encourage the Patent Office to do some experimentation and that might help them through the experimental process. It might give us a better sense of how to actually optimize time allocations. So I would rather see this be in a more sort of an iterative process as opposed to us suggesting the right answer, which I don't think we know from the start. Although I'm confident to do something might be advisable. Ultimately, one of the implications with our this paper and the prior paper is that ultimately those scaling factors may not necessarily be properly configured, and then ultimately they might be the amount of time that is cut as examiners progress throughout the career might be a little bit too aggressive, and that might be contributing to why there is this sort of strong grant rate gradient across these particular grade level promotions within the Patent Office, which might raise concerns both about, well, this could be contributing to sort of the issuance of invalid patents to the extent that those time constraints it's too aggressive and time constraints are binding, and it might be causing examiners to issue invalid patents on the margin. And it also just raises equitable concerns as well, so that ultimately we do think our results give us reason to suggest maybe we should rethink these sort of scaling factors as well, and how amount of time given to examiners changes throughout their career. And ultimately, it's going to take some work to sort of fine-tune all that and to sort of to strike the right balance. So I think, cautiously, I'll say at the end of the day, both I think we should probably be doing some work and thinking about expanding the amount of examination time given to examiners, and then hopefully informed by some amount of experimentation, but also do some amount of rethinking about how examination time scales throughout a career to address these various problems.
So that's it for today, guys. Daniela, thanks for being with us.
Yeah, thanks for having me. I mean, I really enjoyed reading Michael and Melissa's paper. It's very thorough work. Can definitely recommend it.
I agree. And you guys, you know the drill. If you want to learn more about law and economics, hit the subscribe button below. Cheers.